All right, so my name is Mr. Max Chaudhary, and I hope you can hear me. Somebody can maybe indicate.
Yes, good, sir.
All right, that's good. And so I have this webinar typically, excuse me, on the third Thursday of the month, and it's being recorded. And keep in mind that if you pose questions, try to keep them anonymized, because portions of this may end up on social media just as a form of promotion for my law firm. So essentially, that's the sort of method to keep in mind. And also, the purpose of this is to provide general guidance about Canadian immigration matters. That's as opposed to substantive advice, which would require a more in-depth view of the circumstances of the person who has an immigration question. So more in-depth examination is synonymous with doing a consultation, where we can employ things like a checklist for certain things, depending on the type of goal, visa goal or otherwise, that the person has. By contrast, today, I would want to accept questions in the form of text, I think, primarily for this. And I mean, I know it's sort of the time of the year is such that there may not be a huge amount of response today because people are busy with holiday-oriented activities. But nevertheless, the purpose also is to provide some guidance in the face of pretty confusing sources on the internet. Even the official Canadian immigration website is sometimes confusing because it includes further, not just law and regulations, but also policies that are meant to provide guidance for officers. And those policies are not necessarily binding on an officer, but they're considered kind of persuasive guidance. So people who come to my office and tell me they look up things on the internet sometimes don't make that distinction and treat policy sometimes as binding law, which isn't always the case. So with that sort of background in mind, let me open up the chat and say this meeting shall be recorded, and then further, please pose your questions in the chat. And then let's see here, let's see. In the meantime, I have to sort of admit people as I see them here emerging in on the list. So that's the sort of the occupational hazard when you have a sort of open-ended kind of setup like this. So for anybody who's joining, maybe I'll just reiterate what I just said in the chat. So okay, I see a question there. Let me just finish this. Please post your questions in the chat. Please keep questions more on the anonymous side. Okay, and so I see a question in the chat. So I think I can commence. And then for anybody who's recently joined, also, please feel free to pose a question in the chat. And as often happens in these situations, sometimes context might be missing, or for maybe something on my side necessitates or maybe causes me only to answer the question partially, in which case, in those circumstances, you can add or alter or pose another question that might be similar to the fact situation that you might have initially posed. So that's in the event that the question, maybe it was not clear to me or some context was missing. So with that sort of background out of the way, let me try to tackle the initial question I see here. So it's talking about temporary stays. So somebody's indicated, my preliminary research indicates an American citizen can stay in Canada for up to 6 months, working remotely for an American company without a visa. So is this correct? So one thing to keep in mind, which is the employer, if the employer is not in Canada, and if the clientele of that employer is not in Canada, then you're not participating in the labor market in Canada. The analogy that comes to mind is, information technology workers in software, where they're dealing with software of their client, but their client is not in Canada. Their client is elsewhere. But with their laptop and sufficient credentials and security, they can access and alter and do whatever is necessary for the software-oriented job that they have to perform. And all of that is not taking away jobs from Canadian people. That's merely somebody who is inside of Canada, who is getting paid from outside of Canada. And presumably their money is going into their bank. The bank is probably, assumingly, in the country of ordinary residence, which perhaps might be the United States. I want to emphasize, though, there's no Canadian clientele. Otherwise, you would be participating in the labor market, and you would need a work permit. I think it bears mentioning there was the mentioning of the 6-month period of time. So what is the norm is that, for example, if you're an American citizen, and similarly, if you're from a visitor visa exempt country, such as most EU countries, then the norm is when you enter Canada, you may only need what's called an electronic travel authorization. American people don't need that, but these other countries, they need that. And then the norm in these situations is that if you come to the airport or come over the Canada-US border, hopefully they stamp your passport if you're at the border, so there's proof of when you entered. And similarly, when you arrive at the airport, they will stamp your passport at the airport. It's routine. And the presumption is that you're allowed to stay for 6 months. And what you may or may not know is that if you want to stay for an additional 6 months, you do not have to necessarily leave, but you can apply for perhaps another 6 months while remaining in Canada if you submit that application before the initial 6-month period you were allowed to enter Canada has expired. And then that's making for an application for what is called a visitor record, which is basically extending your status as a visitor. Keep in mind that you need to fulfill certain criteria, like show you have enough money to stay as a visitor. In other words, you don't need to work because they're concerned about working illegally. And they may want to see some evidence of the purpose of the additional 6 months. The purpose has to be a temporary one in most situations. There are exceptions. Maybe if that comes up, I will get into that. So in this case, you would not need a work permit, at least based on the sort of background caveats I filled in with this. So hopefully I've disposed of that question with sufficient context for the poser of the question. If not, please pose something in addition. So we have a handful of people here, and if there's any question, oh, okay, I see one, a fresh question here. So if I sort of digest that, it says, can I get my parents' permanent residency on humanitarian and compassionate grounds, I will say. And the background is that both me and my brother are here in Canada. I'm a Canadian citizen. My brother is a permanent resident of Canada, and nobody is in India to take care of them. So this is a ongoing issue, because if you I'm sure the poser of the question will know that the permanent resident sponsorship program for parents has been paused for new applicants. They are only selecting candidates or parents who had Canadian children who put the parents' names in the expression of interest pool up to the year 2020. So the idea was that too many people wanted to bring their parents to Canada as permanent residents. And the previous years, some of the years it was a lottery, so it was first come, first serve. So people were just disappointed. And then they changed it to, I believe, 2019 and the year before, 2020 as well, as just a lottery. So there is a pool of candidates. It's a huge pool because they've selected people from the last pool composition, which was filled in 2020, and they still have plenty of candidates there in the 2020 pool who can be selected to apply for permanent residency. So that's created many, many queries by Canadian citizen or permanent resident adult children who say, well, my parents wants to come to Canada permanently. There's at least officially a sponsorship program which has been paused. So what are the other options? So the option being queried here by the person asking the question is humanitarian and compassionate. So when you think of humanitarian and compassionate, it's very warm and fuzzy, those terms, but in terms of the legal kind of framework for a humanitarian compassionate application, the broad sort of pillars of that application are some degree of ability to economically establish in Canada. And the other one, before I get into both, the other one is some degree of hardship that cannot be allayed by filing some other kind of application. So in terms of the first one, economic establishment, obviously there has to be a context. Now, this is where I get into more details, which is more pertinent to this question. So economic establishment could mean many, many different things. The very, very basic definition of economic establishment is to show you have enough money that it looks like, arguably for like at least 5 years, you will not appear to look like you'll be depending on social assistance or any form of government welfare. That's harder to prove for parents because they don't normally, even if they visit Canada, they don't have a right to work. That being said, the federal court has mentioned that establishment has to be defined differently for people who aren't working age. So one clue about how they might, or you might establish or show economic establishment is show you, the would-be sponsors who can't sponsor because there's no sponsorship program, but you, the child or children who are in Canada, constitute a definitive support network for them, economically speaking. Maybe you have a residence, you can house them yourself. Maybe you have savings, things of that nature, which can be shown that your non-working age parent will not constitute an economic burden. They will be established based on your economic establishment. So that's one component for a successful humanitarian and compassionate case for parents. The other one is some degree of hardship which cannot be allayed or mitigated by some other form of action or privilege or application under Canada's main law, the Immigration and Refugee Protection Act. The one that I suspect will cause a lot of difficulty is if you file a humanitarian compassionate application for your parent, and the officer might say, well, we have this other visa, it's called a super visa, and you can stay for, I believe, 5 or 10 years nonstop on that super visa. The requirement, however, as you may know, is that you have to have private health insurance because you can't be a burden even as a long-term visitor in Canada. That could be an issue for this. The other requirement, though, in terms of the permanent residency for humanitarian, by contrast, is some kind of hardship. So if we look at the specifics of that question, nobody's in India to take care of my parents is basically the sentiment at the end. This is where some officers who have specialized expertise, maybe some visa officers who are Canadian, they may have visited for the purpose of being a visa officer in India or other countries as well. So in those cases, they tend to acquire specialized expertise about the nature of what is available to elderly people in India. So there could be a concern that you could delegate some of the care of your aging parent in India based on, for example, the fact that you make developed world, first world currency money and you pay other people in rupees in India when that arrangement on the face of it might be viable. So it's something you'd have to address in your humanitarian compassionate application as well. What is the severity of the potential condition of the parents, which means that they need more personalized care? Or is the care where the parent is simply not good? Do they have an unusual health condition? This is where the concept of hardship has to be not just being lonely, but there has to be something very specific. In some countries, elderly people are targeted on the basis of being perceived to be wealthy and hence targets of crime sometimes. That in the situation where police cannot be relied upon, like in some cases in India, you file what's called an FIR, which is an initial police report, and then nothing seems to happen after that. If that's the phenomenon, then the presumption might be that in a solid, good humanitarian compassionate application, your parents did have an incident and they went to the police and they received the FIR, and a year later the police did nothing, and then maybe another incident occurred. So that's a pattern. Then in that situation, it could be seen that there is a kind of hardship which exceeds what we call generalized risk, which is a sort of risk to the general population. And that might be a more robust component for this issue of the hardship related to a humanitarian compassionate application for this. So I've sort of touched upon the two sort of pillars, which is hardship, the second one, and the first one I mentioned was economic establishment, which varies from case to case. So those are the basic ingredients for this. When we do humanitarian compassionate applications, we'll get country condition evidence. Some of that's, I mean, if you're really good at researching, you will find some evidence that, for example, if you're of a certain ethnicity in India or certain language group in India or religious group, sometimes you could be targeted. Similarly, you can find evidence about the issues relating to gender, to women, and then you have to be careful because the officer as well may also find information about gender issues, and they may say, well, there's women's shelters in India, so what's the problem? So it's a very document-heavy application because it's so discretionary. The section is section 25, and it's just a couple of sentences long. So that those two sentences are meant to be a catch-all or a safety valve for people who are interacting with the immigration system, and they will suffer some kind of notable hardship that cannot be mitigated by some other kind of application, or cannot be mitigated by simply leaving Canada, because then you're maybe sort of adding fuel to the fire by going to the country of difficulty. So I hope that provides some background for this. H&C for parents question. So I think there's a follow-up to the initial question, which is, do you assist short-term visitors with assistance in applying for visas for other countries? So if I understand the question, we're not licensed to provide immigration information for visa applications to other countries. I think that's a short answer, unless I've misinterpreted the question. But with that in mind, if I did, then please repose the question accordingly. So I want to, since I don't see a question and I still have time, sometimes I make a comment and that could spur a question. The sort of elephant in the room for the previous webinar was the fact that the U.S. election had just occurred, and now we're anticipating seeing an uptick in queries because there will be a U.S. inauguration for the next president of the United States. And so the concern is not only for U.S. citizens, but also people with who had or have a pathway for permanent residency in the United States, or have maybe on a temporary visa like an H-1B work permit. And there is some question about what the new American administration will do, leading to queries about this. And this is being compounded by our Canadian government, because we're supposed to react to that. And in some senses, we're corroborating some of the concerns, because now there was an announcement yesterday that will be sort of an airborne monitoring of our very porous and undefended border, because of the phenomenon of people smuggling over the vast empty swaths of the Canada-US border, which is a problem arguably worse in the summer, given the weather. Obviously in the winter, it's not as big an issue, but all of these are sort of going back to the theme of tightening of the criteria for immigration in many countries, many of the developed countries. So this issue is not just for Americans who are very troubled. It's also Americans who, from what I've seen thus far, Americans who are transgendered, same-sex couples. There's even a query about some American who might become pregnant and may have an issue with abortion and things of that nature. So there's really the sort of intersection of political policy and immigration policy affecting or being amplified in terms of the narrowing of the openness for many of these borders. So that's sort of the context for what has happened and what I anticipate will keep happening for this. So with that in mind, we still have plenty of time. And I do see a question here. So with that in mind, I see the question. If I just read it verbatim, then try to digest it accordingly, I'll see how far I can get. So it mentions that if I move my online United States business to Canada and register it in Canada and operate it from Canada with US customers exclusively and no Canadian employers, and pay taxes in Canada, so would that qualify, or would that be within the ambit, I would say, of temporary resident status? So one concern is that if you register a company in most provinces, and I'm not a corporate lawyer, I just know some basic law, but if you register a company, an incorporation, then in most of the provinces, maybe not all, the majority of directors have to be Canadian. I mean, that may not be a big deal. There might be an exception for British Columbia, where maybe you don't need the majority of directors to be Canadian in an incorporated entity. And then in this case, the business would be, let's say the business is properly registered with that proviso about requirement of Canadian resident directors or non-resident, for example. Then let's say the company, which in this scenario has clientele outside of Canada, which is not serving clientele inside of Canada. And then the question is, if the taxes are paid on that, would that qualify for temporary resident status? So this issue of the taxes is something I can only say with sort of a medium amount of confidence, because the sort of lens that immigration lawyers operate from are business activity and whether it's triggered, whether it triggers any obligation to possess a certain kind of document under the Immigration and Refugee Protection Act, or IRPA. So in this case, it sort of harkens back to what I mentioned earlier. So it's a business. It's not competing with Canadian businesses. It presumably would have no employees in Canada. The revenue would be from the United States. But one thing you have to check is the payment of taxes, because the company is a person under Canadian law. So that company would earn revenue. So now don't quote me on this, but the presumption is that it's a company, it's a person in Canada, a corporate person. So whatever revenue the company makes, taxes should have to be paid in the ordinary course of events. I mean, there's probably loopholes or things like that if you have affiliates, but that's more like a tax accountant question about the tax aspect of this. But if you're, the issue is, if you're managing the business, then that's a problem, because you could hire, or you should hire, a Canadian manager. So one possible solution might be that if the company is already established for more than 1 year outside of Canada, then you could, well, there's a bit of change in this law about intra-company transferees. But before the policy changed, you could simply open another branch, an affiliate branch in Canada. And that branch, the sort of nuts and bolts of the branch to be opened, initially at least, would be subject to scrutiny by a Canadian visa officer, and they would review the business plan in the context of you filing for a management-based work permit to work exclusively on a closed work permit for that to be newly established Canadian branch of the US branch. So that's not a problem as long as you make the business case for this, which means you may have to show that there is a business rationale to open the branch in Canada. So when I looked at the question, then if the clientele is not Canadian, then ostensibly it's not looking like it's a business maneuver to expand into a different market. It looks more like the primary purpose is just to get residency in Canada. And that's still okay, but the problem is you still have to get a work permit because you're acting like a manager instead of hiring a local Canadian to be the manager. So all of that is to say that probably, in at least the way I've kind of maneuvered it through the ICT, or intra-company transferee, you'd need that form of work permit, a closed work permit on a new branch. Now, there was an announcement recently about ICT, which said that your initial company has to have a branch in 2 countries, not just, let's say, America, the United States, but another one before it has another branch in Canada. Now, there may be exceptions to that, but that was something that loomed large to us immigration lawyers, because that automatically made it less favorable to small companies, which may only have a branch in 1 country. So it seemed almost as if they were maintaining this benefit for large multinational companies, but by adding this requirement to be in 2 countries before you enter Canada, the 3rd country, you're causing many companies to be disqualified from doing that. So that's sort of the background about what you might contemplate in that situation. But the bottom line is it's a work permit based on how I'm seeing the question. So with that in mind, we still have plenty of time. So with that, I want to make sure that if there's any follow-up question, or if somebody has joined recently, then they can type a question in the chat as well for this. In the meantime, the other, as I indicated, the sort of tightening of the all of the immigration programs, even the one I just mentioned, which it was a very business-centric program, but even these ones, which are ostensibly meant to benefit the economy of Canada, even these types of programs are having some added restriction to them. So that means when these policy changes happen, I mean, they're embedded. If you have like a Google alert or a skilled Google alert, like a lot of immigration lawyers do, you'll be on the ball with these sorts of things. But in the absence of that, the concern that that I have with laypersons is that they're crowdsourcing information. Like there's various Facebook groups and other groups as well, where people crowdsource a question based on anecdotes, and maybe somebody has gone through a similar process and they describe that in their anecdote, and that might be construed as sort of a green light to do a similar course of action. But the issue, as many lawyers know, is that every case is always different slightly, and some things which may be construed as a slight difference could have severe implications for the other case, the subsequent case, which has a key difference, which may not be apparent to the person who might be wishfully or willfully blindly looking at the sort of analogous case that they might have come across in a Facebook group and think that they have the green light to proceed. So this is sort of the, we see this sort of in the, I think the anecdote, I think we're all guilty of like looking up a medical condition when we have a symptom. So it's sort of analogous to that, because sometimes if you look up a condition and you look 6 steps deeper and then says you might have cancer or something, right? And then you're wondering what's going on. So it's sort of the opposite with immigration. You're subconsciously looking for the green light or the go ahead. So you're sort of in the back of your mind, you're looking for somebody who had a similar situation in your mind, and then you see that they did something and it was successful, and you go for it. And then the negative consequence is that there's a refusal. The even worse consequence is there's a refusal with a 5-year ban under Section 40 of the Immigration Refugee Protection Act. Because a 5-year ban under Section 40 means that in some cases you can never come to Canada. I mean, I'm speaking about people who are younger, who want to come through the normative economic stream, which is highly sensitive to age. I mean, the points for age under the express entry peaks at around age 29. So in many cases, a refusal is a bit harsh, but a refusal with a 5-year ban might mean that you have no chance of entering Canada. And then keep in mind that the English-speaking countries of the world, they call them the Five Eyes, New Zealand, United Kingdom, America, Canada, I believe Ireland as well. They share immigration information with each other. So if you have a visa interaction that's negative in one of these countries, the Canadian government can access that, and vice versa. So if you have a Canadian refusal, then the New Zealand government, at least from what we're told, they could access this. So it's important to not utter a falsehood if you try to enter another English-speaking country. If they ask, have you ever been denied a visa to any country, or ever been detained, or ever ordered deported from any country? So it's something to keep in mind as well. This is sort of the sort of background to having some degree of caution when trying to navigate these things on their own. This does occur because the Immigration Department, at least for Canada, they're quite enthusiastic about people filing things on their own, because they don't care what the disposition is. They simply like to have a lot of activity in their department which justifies funding of the department. So that's sort of the sort of cautionary tale about trying to get some definitive answers based on some research on the internet. So with that in mind, I see the corner of my eye, so a little something in terms of a possible question. So looks like related to the previous question. So it's, if I move my online business to Canada and registered in Canada and operated from Canada with US customers, no Canadian employees, and pay taxes in Canada, so would that qualify as temporary resident status? This reminds me of, I think, the same question. Like, I thought there was a new question, but that's just on me. So with that in mind, we still have time. I guess, like I said, this time of the year, people get preoccupied with more festive things unless they have an urgent issue, which oddly enough, if you talk to a Canadian immigration lawyer who's experienced, they will tell you that there's an uptick in detentions and removals during the Christmas time because a lot of lawyers take time off. So there's a little bit less pushback. And I think a lot of lawyers have told me that. I think I've noticed it as well. But that's more of a, so that could really become sort of a downer on your holiday plans in Canada if that happens. So let's hope that's not a situation that's going to befall anybody this year as much as possible for this. So in terms of any other question, there's nothing new here. So the other sort of general kind of comment, which I think is always appropriate, is not just these looking for the right answer on the internet in general, but also the issue of border interaction, which does occur, and what happens when you approach a Canadian, let's say either port of entry, airport, or Canada-US border, and they find there's difficulty, and you want to, for example, come as just a visitor, and they ask you some questions, and then let's say they discover that you currently don't have a job and you don't have any assets, or you don't have significant assets, maybe a savings account. And let's make it even more specific. Your working age, you're like under 40. And so that forms a profile that you intend to work, even though you said very clearly that you only intend to visit for 4.5 months. In those situations, they could express the concern that you're not a genuine visitor, and then they could give you the option to leave. And then there's a paper that's called allowed to leave. That's what you would end up with. So what I see, again, I see this with the odd American client because we have a land border. So what's happened sometimes is that they get the allowed to leave notice, and then 3 hours later they just go to another port of entry. Maybe instead of Niagara Falls Peace Bridge, they'll go to the Rainbow Bridge in Niagara Falls. And the problem is the allowed to leave notice is in the computer. So it's not like you're starting off with a clean slate. It's just that you don't have a report or deportation against you. So you could be stoking some temptation to issue a removal order or investigate further if you sort of become overconfident by having this allowed to leave notice. The more appropriate course of action would be to kind of review what the concerns were and see if you could eventually configure your application to enter with better evidence, such as maybe a job in the United States. So things of that nature. This is sort of the universal thing with border interactions. People, I mean, it's universal. Everybody gets nervous when they're crossing the border, but when there's a little bit of desperation because maybe they have to meet their loved one in Canada, lose their sense of judgment, and they, in the sort of parlance of the immigration officer, try to pull a fast one by trying to pay a visit to a different port of entry or a different land border, for example. So these records are somewhat robust, and concurrently, it's the other issue is that sometimes you want a bit more interaction. For this is an issue particularly at the land border, where you want them to stamp your passport because you want to clearly confirm and have objective evidence that you entered Canada on a certain date. This happens when you're, for example, an American passport holder, and you want to have that date in your passport so that, let's say, you want to stay for a year as a visitor. So at the, say, at the 5-month mark, you can point to your passport and you can look at that stamp, and then you can make that stamp the foundation for an additional application to stay in Canada for another 6 months. But let's say you don't have that stamp. So then what can you do? Well, you can try to ask for a sort of freedom of information request from the Canada Border Service Agency. But you'd have to craft it in a specific way, saying, I want to know the entry for on this date for the car license plate so-and-so. This is, for example, if you entered Canada in a private vehicle, because they might be able to track your entry that way. You'd have to get that record, and then you'd have to tell the Canadian immigration officer inside of Canada, I don't have a passport stamp, but I got this record from the Canada Border Services Agency with this license plate. This license plate is my girlfriend's or whatever, or it's mine. And that was the date I entered, and it's corroborated by the Canada Border Service Agency record. And then you get something. You get to file for a renewal. So that's the time when, because the land border is so busy, when they think you're really, really, really routine, they'll just say, okay, fine, just go. And then if you're lucky, you can ask them nicely to stamp your passport in that situation. So that's the other concern that you want to make sure about in this. So the sort of pattern is that the border people, if they're enforcing the law clearly, then if they think they're enforcing the law by not letting you in, then they will take an active role. But if they're busy and they think you're not a risk, they're not going to really go out of their way unless you're perhaps very charming and explain the rationale for something like, can you do this extra thing, like stamp this passport for me so I have proof? And if they're nice, they should. Right? So with that in mind, now we still have a nominal amount of time left. And it's always good to get sort of, we sort of say on the record, but I mean, this isn't a court proceeding, so this is more just the sort of frequently asked questions component that I sometimes have to get into when we have people who just sort of call our office and things of that nature. So the other sort of along the same lines in terms of the frequently asked questions relates to what can I do now as a young person who was kind of implicitly promised that I could get permanent residency because, for example, and this is sort of the common one, I'm a young student from the state of Punjab, and from a poor family. My family sold a plot of land so that I can get a study permit, and the study agent in India promised that I'd be going to the best university and it's a guaranteed track to permanent residency. And then I come to Canada, and then at least as of, let's say, July 2022, the points for those young people or the pathway that was allocated to them or promised to them under what's called express entry, which has its own sort of fluctuating point system. The points went way over the normal ability to qualify, because normally the points were around 420 to 470 until about July 2022, and now they're over 500. So to give you a sense of what over 500 means is that, you have to have a master's and be fluent in English and maybe fluent in French, 2 years of work experience, and then you might get 500. So in other words, the pool of candidates that are able to immigrate is very low. And a lot of these kids, I mean, not all, but quite a few, they had sort of this toehold to come to Canada because they sold something huge to their family to get the tuition and the 1 year work experience. Then the kid struggled working part-time while going to school, and then graduated because they were able to pay their tuition for the 2nd or 3rd year by working in Canada. The system used to be that once you graduate, you get a work permit and work for 1 or 2 years. And that's still true. But usually after that 1 or 2 years of work, you would have enough points under the expressentry system for permanent residency. And that was the case from 2016 until like July 2022. And now these kids are in Canada. They have a degree. Some places, in some institutions, the degree might not be useful. The consequence is that they don't have a pathway yet. They've made Canada their home for, let's say, 3 or 5 years, maybe 2 or 3 years of studying and then 2 or 3 years of working. And then there's no pathway. And then the sort of trite response from the Canadian government was like, well, we never promised you that. And this is where the law is kind of true. They never really promised this. This was sort of the work of these sort of agents who are not licensed in these countries, these developing countries, primarily India and China. A little bit in the Gulf statelets as well, where they were saying it was a pathway. And anecdotally, it was a pathway for a lot of people, but now it isn't. And now this has led to the distortion of all these other sort of alternative pathways where you have fraudulent labor market impact assessments. Those are the applications which lead to an extra 50 to 200 points into the express entry system, depending on the type of nature of the job that you were getting. And there's rumors of these false LMIAs costing $50,000. And sometimes the person is just out of luck. They just paid $50,000 and they have nothing, right, for this. And that's leading to concerns, which I am hoping are not happening, which they're saying, the government is saying that they may get rid of the extra points for the labor market impact assessment. And similarly, they may only allow for work permits after studying in Canada in certain occupations. So that's kind of going back to how the law was before like 2008, where after graduating, you could only work in Canada if you had a job offer. And it wasn't that difficult to get, but now that there are so many international students in Canada, this is leading to a public outcry because, local Canadian children are having difficulty getting these jobs. So that's sort of the a very frequently asked question that I'm getting in the past year or so. So I just want to make sure that in case it comes back, I can point to this on the internet, for example. So and with that in mind, I thought I saw another question. I'll just see here, right? So this question relates to the impact of changed immigration laws. So when Canadian immigration laws become more stringent, are there usually grandfathering clauses for individuals who obtain status lawfully before the laws change? So in terms of sort of the spectrum of how this works, right? If you this could be very troublesome if I'll just use the example I just gave. So students, which I hope doesn't occur, but as I said, the norm is you graduate from a public institution at the post-secondary level for at least 2 years. And under the current law, you're allowed to file for a work permit, and it's an open work permit. You don't have to have any experience. So then if I sort of tie that into this question, then would the fact that the student entered Canada on a valid study permit and graduated, and then would they still be allowed to file for the open work permit? So unfortunately, no, they wouldn't be able to do that, right? The problem is that the norm is that there is no sort of retrospectivity in the law unless they add what we typically call in the law a transitional provision. And that would usually resemble something that says, well, hopefully we would see something like this. But in this context, it would say something like, for those persons who possessed a study permit, let's say from September 2023 up until the change of the law, let's say in January 2025. If people possessed a study permit within that window of time, they could still file for an open work permit. But the problem is this would have to be explicitly stated in the law in the form of a transitional provision. So instead of section 27 sub 1, it'd be like section 27 sub 1.2. It says transitional provision. It says if you're in this sort of category, then the first subsection wouldn't apply to you. You can still be able to file. These transitional provisions are more common when there's the interests of a vulnerable group that might be affected. So like a minor age child is where we commonly see transitional provisions, because we don't want to see children who are like sort of separated from their parents or who can't come to Canada for a certain kind of situation. Right? So those are, I'm hopeful that there won't be something so harsh in these kinds of situations. But again, if you read the paper, and particularly the past 2 days, you'll see the current prime minister we have is not very popular at the moment. So that's sort of not a good bellwether for what will occur, which is a potentially more conservative reactionary government in, I suppose, October 2025 for this. And so that would unfortunately sort of lead to the sort of, it seems, worldwide trend of more sort of reactionary and conservative policies, including with immigration. So I think with that, we still have a little bit of time. So I can go into another frequently asked question, which seems to come up, because I've seen the one, which was the parent one. That one has sort of become an evergreen one since they stopped the parental sponsorship program. The other one relates to, can I come to Canada with just a lot of money and not have to do anything? And in the old system, that was called the investor program. And the investor program was a passive immigration program. It was basically a shameless cash grab. It used to be available in all of Canada, and then slowly it died out. And I think the last province that had the investor program was Quebec. And the program, as it stood, I believe, in 2014, which I think was, it may not be the exact date, but that stood that you had to say you would invest $800,000 and you had to have a net worth of 1.6 million Canadian dollars. And so this was great for people who just had a lot of money and they had their foreign business and they didn't want to disturb their foreign business and they wanted to keep managing their foreign business. So they would immigrate the family, and then they would drop off the family and they would probably keep working at their business in China or the Persian Gulf or the States, I suppose. And then they sort of had a sort of cushion for their family, at least. One reason that this program no longer exists is that by the time it was only available in the province of Quebec, most of the candidates were Chinese candidates, and I think some Russians. And so Quebec would collect the $800,000, and then the mostly Chinese candidates would move to British Columbia, and then so British Columbia would be the ones that would be servicing them, and they would not get the benefit of this investor money. So the provinces complained, and now it's paused. So we don't have this passive program for immigration for really wealthy people at the moment. I think they're just trying to figure out how to get around that loophole. I think they may, if it does reemerge, I suspect they may have some kind of reporting requirement tied to that, which means it would be a conditional visa. For example, that you must reside in Quebec for a certain amount of time, or things of that nature. So we got like a few minutes left. So I don't know if that's a question, or is that like...
Yeah. So, sir,
Oh,
can we apply on the normal way, like the procedure which we apply without any, like it will take 10 to 15 years for the parents, right?
oh, you're talking about parental sponsorship.
Yeah, yes, sir.
Okay. Oh, you're talking about the ordinary method, right?
Yeah. So, as you mentioned, like I heard it all. So it's, but it's a genuine case if like I apply on that one, right? It's my parents are alone over there. So, but if that
Mhm.
file is reject in some of the case, right? Any of the reason. So after that, can I apply the reapply on the normal way or the same like?
So this is a situation, I think, where let's say you're not a part of the pool for sponsoring a parent, so you file it as a humanitarian case, the very discretionary way for your parents. And let's say that discretionary way is denied. And then the question is, let's say the regular sponsorship opens up again and they're accepting new candidates. Can you put them in the pool if this pool reemerges? The short answer is yes, but keep in mind, if you file for a humanitarian case, humanitarian cases are often, but not always, associated with the person being inside of Canada. So as long as their status in Canada is maintained and they don't have a violation, such as an exclusion order, which is the fancy way of saying they've overstayed and they got caught, then it's fine. On the other hand, if they have an exclusion order, official exclusion order, then they're barred from Canada for 1 year from the date they leave. So there could be a slightly problematic situation where, let's say you did the humanitarian case, it got denied, and all of a sudden this program reemerges, the ordinary program, and then you put your name as the sponsor of your parent in the pool, you get selected, and they say, wait a second, your parent was issued an exclusion order and they didn't leave, so the 1 year clock hasn't ticked yet. So then there's a risk that they could deny the sponsorship, and then you would have to appeal that at the Immigration Appeal Division of the Immigration and Refugee Board to say that, yes, it's true, my parent had a 1 year exclusion order, and the 1 year did not elapse because they simply stayed in Canada. Can you let them stay on humanitarian grounds? So then the humanitarian compassionate argument becomes or reemerges again. But keep in mind that at the IAD, the Immigration Appeal Division, the concept of humanitarian and compassionate is much more robust because you're face to face. Well, at least Zoom, like you're on a Zoom hearing these days. So the parent can be a witness. You, the sponsor, in that refused case, can be a witness, and you could express, hopefully armed with cogent documentation about the dangers for them to be in their home country, and the fact that you have always been a vital support for them. So there is a very stronger than average parent-child relationship, and that you have sufficient economic establishment as a sponsor, and you're maintaining your job. And then in that case, after that appeal, you could conceivably still be successful in having your parents come, even though they have an exclusion order. So it's a roundabout way of saying yes, but it may take many steps for that. So let me just see the chat again. If there's, hopefully I didn't miss anything, right? So I think we're almost at time. I don't think we have a particularly cogent set of questions anymore. We had a pretty dense set of questions with a follow-up. So I'll just hang on for a sec. And then if there's any other things, then since we're at time, I think you can enjoy the rest of your evening and have a good evening. Goodbye.